The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And good afternoon. We have three cases that will be submitted. Those cases are State of Iowa versus Evan Headley, Winger Contracting Company versus Cargill, and the final case is Iowa Attorney Disciplinary Board versus Melissa 9. The last case is now submitted to the court without oral argument, and we will first hear the arguments in Headley. Ms. Wilson.
you're asking for things to be split up. You're saying if they don't know the amount, you can come back later and determine that or make an estimate. Don't you think there's a pretty good chance that the estimate's not going to be spot on and you're going to end up doing it all again anyway? I think the ability in this case, I thought it probably wasn't right because the appeal was before the restitution amount was determined, therefore not necessary for the court to make that determination at that point.
At the time of sentencing, the defendant didn't request a determination be made, did he? He didn't object to saying that there will be restitution at that time, did he? But it seems to me that whether a defendant has an ability to pay is one of the key factors is the amount. I mean, if the amount was $100, I mean, most people could pay $1 a year and pay it off in whatever, or $1 a month. If it's $14,000, you get a different result. In this case, the appeal was taken March 28th, and the request for reimbursement wasn't until June 8th. So how does a court make that determination? I mean, we do have a procedure under 910-7. If once the amount's filed, you can ask the court, you can petition the court and say, if you do it within 30 days, you still get your attorney, and you can petition the court and say, I don't have reasonable ability to pay, and have that hearing. So why would we want to front-end load it and do it twice sometimes, as Justice Christensen said?
Ms. Wilson, could you pull the mic just a little bit closer before you answer? Thank you.
But will they know how long he's going to remain in jail until incarceration in the prison setting?
Okay, Ms. Wilson, I'm going to ask you to pause just for a minute. I don't think our mics are working, and does someone want to come up and take a... That's okay. We'll just have to soldier on then. Could you put 7 minutes on the clock? Okay. I'm sorry. Thank you. Please proceed.
There's a problem by doing it piecemeal as the defendant is missing the opportunity for a full vetting of these amounts and presentation at the time of sentencing. That's the preferred practice in your view?
Help me out, Ms. Wilson. Give me an exact, quote to me a statutory provision that you say is being violated here.
What does the next sentence say? If the pecuniary damage amounts are not available at the time of sentencing, the county attorney shall provide a statement of pecuniary damage occurred up to that time to the clerk of court. These statements shall be provided no later than 30 days after sentencing. I mean, there is a provision to let you do it after the fact if they're not available.
It's not very practical, though, is it, for all of those numbers to be immediately known on a motion day, for example, when a plea is being taken? And all of those numbers, they do require not just one person determining. You've got the clerk's office involved, the sheriff's office involved, the contract attorney or the public defender's office involved. So there's a lot of moving parts. So doesn't it make sense to allow those moving parts to get together and provide the due process, which is an opportunity to be heard on it? Because I don't think it's as much of a global problem as what you're saying. I'm trying to help me understand.
What
If there are
about
any
the sen-
if there's any post-trial motions, public defender's going to put more time into bill. If there's any more time in jail, sheriff's number's going to change. I am pretty sure there would be more than one hearing if we do it the way you are insisting it be done every time.
What about the second to the last sentence in that same statute that says if the full amount of restitution, not pecuniary damages, cannot be determined at the time of sentencing, the court shall issue a temporary order determining a reasonable amount for restitution item after that time. At a later date, as determined by the court shall issue a permanent supplemental order. So it does allow for the court to enter an order, and this court did, saying you're going to pay it, and we don't know how much. And then they followed the statute and entered a supplemental order with the amount of the restitution.
Ms. Wilson, thank you as well. Mr. Howe?
Under 910.3, can a reasonable amount, if we follow the statute, be, I don't know what a reasonable amount, so I'm going to determine it later? I mean, is that a reasonable finding at sentencing, what the court did here? But it says you're supposed to enter a temporary order on a reasonable amount of restitution. If you don't know the amount of restitution, is it reasonable? Does the court comply with the statute by saying we'll have to determine in the future because I cannot determine it today? You're going to the amount to pay. I'm going to the amount itself.
Oh,
I mean, what's interesting about this, the language that Ms. Wilson quoted, puts the burden on the clerk of court. Now, the clerk of court isn't going to be in a position to do anything unless they get the information from someone else, right?
Mr. Howe, my sense is that there's the question of someone's reasonable ability to pay is not determined based on any exact standard. It's kind of vague and maybe loose, and courts kind of ballpark it. So if that's the case, couldn't the court, if they're going to work with estimates, use estimates of what the restitution would be to determine someone's ability to pay?
Why did the legislature allow someone to file a petition to contest the reasonable amount of pay at a later date if all the restitution has to be done at the time of sentencing? Do you think that maybe we're in this pickle today, or we're talking about this today because those things aren't brought to the pre-sentence investigator, or they're not brought to the clerk of court, and it's been the habit of the county attorneys? And I don't want to blame it on them because everybody's real busy and there's not a lot of funds in this branch. But there's not the resources to get that all to the judge on the day of sentencing. I mean, you think we're just getting away from doing on the day of sentencing and just putting it off and off? So if they're incarcerated in the county jail, they're gonna have a lot more costs per day while that stuff's being collected, aren't they?
I suppose so, Your Honor, but again.
So it's sort of a catch-22 in those situations. If it takes 30 days to get that stuff together, he has to pay, or she has to pay another 30 days of room and board.
Doesn't the statute require a temporary order of some kind? That is a temporary order to me does not mean we'll decide later. I mean, it's kind of like temporary custody. You decide it based on the facts that are before you. So it may be that you don't have a full slate of restitution costs, but we know there's a $100 court cost, that you know, and maybe a few other cost items are liquidated and available. So why shouldn't we follow what the statute appears to require? which is a temporary order. Well, based on what I have today, there's $500, and based on your current ability to pay, I find X. That would be temporary until a later date, which the statute allows. But it seems to me, ordinarily, a temporary order is not an invitation for a buy. You just say, you know, we're not gonna do it.
I mean, so if the clerk of court hasn't provided information on attorney's fees and jail fees, because they don't have it, which I suspect is the situation, then the court shall issue a temporary order determining a reasonable amount for restitution identified up to that time. The only thing they could identify at that point probably would be things like court costs, basic court costs.
I don't like that language about temporary orders. It doesn't sound like. You don't like the language in the statute about temporary orders. Yeah, you. Yeah, but, I mean, that's what you just argued. I mean, it seems to me, I mean, we're gonna have to follow the statutory guidelines. No question about that. And it seems to me, I invite you to push back, of course, a straightforward reading of the language Justice Mansfield just read is that if there is $100 that we know is subject to restitution and documented, the statute seems to require, at that stage, the entrance of a temporary order based on that information that's known. Now, maybe we don't like it. We may say that's inefficient, but there it is. So I invite you.
At the time the statute was enacted, I think life was different in the 70s because the attorney fees were determined by the district court judge. So the district court had some handle on what the fees were going to be or could have ordered, you know, the bill to be presented before sentencing. I'm not sure we allowed reimbursement for housing back in 75. And all these other things have changed, but they haven't changed the statute. Because now you don't get attorney fees determined until it's submitted to the public defender's office and they approve it. The court has no control over it that they used to. I mean, does that play into any of this, you know, trying to make this statute devised in the 70s with the way we operate now? Has that created any problems? Is the statute broad enough with this, you know, supplemental request able to take care of the changes in the other statutes that probably weren't contemplated here? But we've held though that Say the PSI has in there that the defendant was arrested, while on trial or waiting trial or after trial for crime X, and we've held that if the judge uses that, unproven charge to sentence him, we'll reverse it. So we don't really have that kind of preservation rule as strict as you want to make it. Court in Gonzalez basically said he really did it, I think. They came to the conclusion there was enough to say he did it, so it wasn't an unproven charge.
Well, that isn't quite right. I mean, the PSI has race, sex, age, and so forth in it. You don't have to object to, I object to race, sex, age, and so forth. To sentence somebody for an unproved charge strikes me as a due process problem.
Is it a good idea for PSIs to include the sentencing recommendation from the Department of Corrections investigator?
Mr. Howell, thank you as well. Ms. Wilson, you may present your rebuttal.
You said at sentencing you want to know what? Did you say amount or the ability to pay? What good is that without knowing the amount? Who cares if I say to you, okay, ma'am, I think your client is capable of paying $100 a month. I'm not going to tell you how I came up with that number because I have no idea. I don't have the amount, but I'm going to assess that. Now we're going to go away till we know the amount. What good is that knowledge? Why is it necessary for you to have that knowledge if it's not backed up by anything and is very subject to change? I was talking about restitution. Well, isn't it true also, I don't know if we've talked about this yet, and you can correct me if I'm wrong, but everything, the victims get paid first before everything else. So even if we come up, if we're going to say, and not only, we've been talking about the different categories, we didn't even mention another one I thought of is court reporters, and that changes like water, depends if the hearing was reported or not. Those numbers are all liquid. They all change every time. So if victim has to be paid first, and in a lot of these high dollar restitution cases, they are unknown numbers for a reason. Perhaps there's ongoing medical expenses. I don't know what the reasons are, but those bigger numbered cases, they take a while for those numbers to come in. And like, I can't remember if it was you or the state that mentioned the accommodation of defendants who want to plead and be sentenced on the same day and get going. How is that practical and reasonable for us?
If your client was only charged with the counts he pled to, and none were dismissed, wouldn't the filing fee be the same? But because they dismissed some, you think he should get a credit for it, even though it'd be the same?
It doesn't in some cases, where there's a recommendation for probation, isn't that to the defendant's benefit?
Ms. Wilson, thank you. Mr. Howe, thank you again. The case of State versus Headley is now then submitted, and we'll next hear the arguments in Winger. We'll take a quick little, we're going to stay on the bench, but they're going to try to fix the mic in between the transition.